Thank you very much, Ian. It's a pleasure to be back at Western again. Ian Scott, as you may appreciate, was the managing partner at McCarthy's, which is my old firm, so I am unable to get away from his ongoing supervision of whatever I do or don't do. I appreciate the special horror attending the fact that you will not only have to listen to me for a few minutes this morning, which reminds me to take out my clock, but this afternoon. So what I've decided to do in an effort to mitigate this is to take a proposition and argue one side this morning and the other this afternoon. So the proposition I take is from a book by Leonard Woolf, Virginia Woolf's husband, his autobiography, in which he said, the title of the book is "'Tis the Journey, Not the Arrival That Matters." So this morning I'm going to tell you that it's the journey that is important, and what I'm going to say this afternoon is that actually the arrival is more significant. And I plan to do this this afternoon with somewhat more idealism than I plan to spread about this morning. On one of my other visits to Western, I recall shocking the students by suggesting that the key to a successful legal career was self-promotion and opportunism. And this apparently was somewhat different to what they had been taught by their professors. But I speak from some experience, having risen by the process of serendipity from a Bay Street slip and fall lawyer to an accidental Supreme Court judge in a way that would have gobsmacked my professors when I had my graduation some years ago. Now, you've had a very different law school experience than I had. I would say the great qualification or characterization of my law school time was apathy. The law school was a bit of a backwater at the University of Toronto. I think probably Jason Nair and Grant Huscroft put on more conferences in a year than I had in my 3 years at the University Law School. I have always been shocked by the fact that at Western, some of the students publish learned articles. In my day, even the professors didn't publish very much. One of my favorite professors, Albert Abel, in the late 1950s wrote a piece called Material for Use on Certiorari Applications, Part 1. And in it, he promised a amalgam of overarching generalities and tedious particularities. And in fact, Part 2 never materialized. He always claimed to be working on it, but it just, he had too many other things to do, just kind of hanging out at the law school with the students, and we were all much the better for it. Another feature of my law school was that the professors regularly lost their temper at the students. I don't think that's allowed anymore. I think they'd be up before the Ontario Human Rights Commission. But I do recall in an early torts class, Dean Cecil Wright, who was probably the preeminent legal scholar in the country at the time, talking about that famous case of the man who tried to deter trespassers by setting up a gun, a spring gun, to shoot anybody who came in the door. And Dean Wright was explaining how this wasn't exactly the way to behave yourself. And one of my fellow students, David Kilgore, who wound up as a minister in the federal government, took a different perspective. He thought it was entirely natural that one would set up a gun to deal with intruders. And Wright just went ballistic that he was being disagreed with on this point, and he ranted, and he ended up with the words, he said, "And by the way, Kilgore, you flunked your Christmas exams." And one of my fellow students say, "How come Kilgore always gets his marks first?" So it was a very kind of loose, laid-back, easygoing law school where you were more or less guaranteed a job at the end of it. It wasn't a very well-paying job, but you were usefully employed. And Bay Street at the time was a very different place than it is now. There was, and I hope that this is your experience as it was mine, the kind of apprenticeship system which used to operate where you would follow a senior lawyer behind and you would just absorb the senior lawyer's way of doing things and looking at things and examining witnesses or doing trust debentures or whatever you were interested in. And the extraordinary thing is we all took on the mannerisms of our principals. And there was a particular case, a war hero by the name of Malcolm Robb, who had been shot up as a fighter pilot and who had a bit of a tic. And his law students developed this little tic, although so far as I know, none of them had ever been shot up in a Spitfire. But what it began to teach us was that you had to acquire your own voice. You had to find your own voice. You had to go through this period of transition that you are now just entering in the knowledge that it will take some time to find out who you really are and what it is in law that is going to sustain you in the long run. And here's where I come to self-promotion and a padded resume and opportunism. I remember hearing a speech in the bar admission course by a lawyer called Jack Weir of Weir and Foles. And he said, look, he said, if you get a telephone call from somebody who says, I have a case before the drainage referee, do you do that kind of work? He says, you say yes. Of course I do that kind of work. He says, if you don't say yes, he'll go to somebody else and they'll say yes. The fact is, nobody knows what happens in front of the drainage referee. And you just put yourself forward, learn up, and the next time you then promote yourself as an expert. You know, practice, drainage referee. Oh, I've been there before. In those days on Bay Street, you were pretty well guaranteed a partnership after 3 years. These firms were not money-making machines. It was like joining a regiment. There was mutual loyalty. You signed on and you were really expected to stay there for most of your career. You may come and go doing different things, but there was a kind of a group loyalty to the firm and to the profession, which to me was one of the most valuable aspects of being a lawyer. Now, Bay Street is a different place now, as is London, as is Ottawa, Vancouver, wherever you may set up shop to practice. And I think what is important is that you may now have, in addition to cell phones, a picture in your mind as to how your career is going to play out. You may have this idea, well, I'm going to have an office with this firm, and I'm going to be doing this kind of work, and I have it all mapped out in stages from now until my retirement in 50 years. Actually, lawyers don't retire, but until I stop doing work and devote myself entirely to lunches. My advice to you is to throw all of that away, whether it originates with you or with your parents, and I respect the tremendous contribution of the parents here today. They have their lives, they have their ideas. You have to find not only your own voice, but your own path. I was very impressed at Western a few years ago when the Jessup Moot was held here, and the managing partner of White & Case, one of the biggest of the giant U.S. global law firms, who's a fellow from Ottawa, who said to the students, look, my career is an example of what not to do. He said, when I was a young lawyer, I kicked around doing different dead-end legal jobs. I took on White & Case in Moscow at a time when nobody thought that was going to be of any use in advancing a career. I sort of kicked around the periphery of White & Case and other firms. And lo and behold, here I emerge as the managing partner of this giant operation, purely by seizing the opportunities as they arose and having what I call self-promotion, others might call self-confidence, to take the opportunities when they're offered. And there's no doubt that it's a much more competitive world. Gore Vidal said that, quite famously, that whenever a friend succeeds, something within me dies. And there is this sort of win-lose notion that you want to get ahead, and the way to get ahead is to thrust ahead of the next person. And I don't think that's correct. I don't think that is at all a necessary adjunct of a very fulfilling career in law. In my own case, which at a sort of lower trajectory is been somewhat similar to the White & Case man, Hugh Viano. I joined quite a small litigation firm, and after 3 years went off to Tanzania with CEDA, sort of donated to the Tanzania Treasury to give legal advice. And there were some people in the Toronto legal community who said, well, you know, you get a guy who goes off to Tanzania after 3 years, you got a guy who's not really interested in practicing law. When I came back and was looking for somebody to replace me, a number of the lawyers went to their firms, and the firm said, well, you know, sure, do it, and let us know when you're coming back, and we'll see whether there's an opening. Well, you've got to just take these opportunities. It was probably the most extraordinary experience, professional experience of my life, to have spent that time in East Africa, seeing the world from a very different perspective. I came back to Toronto. I practiced in the same smallish law firm, 1980, doing a lot of competition work. I went down to Ottawa on a exchange program that they had then, they probably still do. Again, going with the government, dead end. You go to the United States, you go to Britain, people go in and out of the government. It's seen as a huge advantage to law firms to have people who know how government works and have contacts within the government. That wasn't the view of the Canadian legal community at the time, apart from my little firm. So, I go down to Ottawa. What happens? But the charter arrives in 1982. Nothing to do with me, but I mean opportunism. There it is, the charter. And the reality is, at the time, we didn't expect within the government, the Department of Justice, that the charter was going to shake the world in the way that it did. You're there, you get involved, you go out defending this, that, and the next indefensible piece of legislation against a charter attack. You get beaten up in the courts, but you kind of get a name for yourself. Binnie, he argued Operation Dismantle, and he argued the Canada Assistance Plan, and this, that, and the next thing. Well, that is serendipity, that is self-promotion, if you will, that is opportunism. But by the time I come back to Toronto in 1986 to McCarthy's, there's a reputation, deserved or undeserved. I mean, half of law, of course, is just being there. You know, you get the name on the law report whether you win or lose. And nobody actually remembers whether you won or lost. All they know is, oh yeah, he goes to the Supreme Court of Canada, we got a case. Well, let's go get Binnie. So what happens? There I am on Bay Street doing some truly horrendous cases in intellectual property, and I don't know how popular it is here, but I spent too many years of my life working on a case dealing with dryer-added fabric conditioners. Bounce, just piece of fabric with some animal fat smeared on it, which you throw in the dryer with a little perfume, and people say, my clothing is smooth. It's covered in animal fat. There's no static. Yeah, well, animal fat's a good conductor. So there it is. You can spend years doing that kind of thing, but at the same time, you keep your hand in the public law stuff, and it may involve working at nights and on the weekends and out of the supervision of Ian Scott so that the dockets don't look too badly. In November 1997, without any anticipation or expectation, John Sapinka dies at a terribly young age after 10 years on the court. The court is under pressure to hear the Quebec secession reference, one of its most important cases. The Chief Justice says, I'm not going to hear this case without a full bench of 9. So they fill the vacancy in 2.5 months. And that's me. If they had longer time, took a closer look, maybe it wouldn't have happened. Chief Justice Lemaire is a perfect example of what I've been talking about, the sort of serendipitous nature of careers. He wanted to be an army officer. Went into the reserve army in the university, was disqualified by a heart condition, had to go into law. Became a defense lawyer, High Court judge, Court of Appeals, Supreme Court of Canada, Chief Justice of Canada. And he once told me, he said, if my career had worked out as I'd hoped, I'd probably be downstairs at the east entrance as a commissionaire, not as the Chief Justice of Canada. So again, don't have a picture book. Just follow the path wherever it leads. So I conclude with these thoughts, which I hope have emerged in what I've been saying to you, which is, above all, don't live somebody else's vision of what your life is supposed to be like. Whatever you do and you feel comfortable in and maintains the kind of enthusiasm you feel now for the law is right for you. If you want to inhabit one of the giant bank towers doing complicated mergers and acquisitions, that's great. If you want to be a storefront lawyer helping, doing poverty law, helping tenants, that's terrific. All of these jobs have their satisfaction. And what's right for somebody else is not necessarily right for you. The second thing is keep your wits about you. As I mentioned with the guy at White and Case, and to some extent myself, you don't know what's going to pop up over the years. Don't get so locked into a career path and a big mortgage and the BMW lease that when something comes up you say, I can't do it. Or if you decide to go into public service, which is a wonderful career, I was told when I went into the public service in the 1980s, look, we got the best clients in the world. He said, they're stubborn, they're stupid, and they have bags of money. So if you do that, and you decide, well, I've had enough, don't say, but I've got so many years in the pension plan. It's too late to pull back. I'm committed. You're never committed. You can always change your direction, and you've got to have the guts to do that. The next thing I want to leave you with is don't underestimate your value to the legal community. You may look out and see these big law firms and you may think, well, they've got all the bargaining power. What do I, as a recent graduate of Western, what have I got to offer? Well, it's actually the opposite. The lifeblood of law firms is new talent. If they don't recruit people like you successfully, they're going to die out, and many have. So they need you as much as you need them. And don't underestimate your importance when you go out into the world as well qualified as you have become at this law school. And I just end with this plea that if it is in your interest, if you like doing court work, if public law, equality law, charter law, any of these disciplines that may not be very well paying, but they're extremely interesting, attract you. Remember that over the lifetime of your career, there will be so many wonderful issues that are going to be debated within the legal community, and they're going to wind up in the Supreme Court of Canada, and somebody is going to argue them. And why shouldn't that somebody be you? Why take a back seat to somebody else and say, oh, well, there are hundreds of people who are better qualified than I am? Remember the advice from Jack Weir. Somebody says, do you go to the Supreme Court? Of course I go to the Supreme Court. And when you go to the Supreme Court, all I suggest you do is to go down a couple of days early, hear a couple of cases being argued, figure out how it's done, because it's very different from other courts and proceedings, and then step up with all that self-promotion, self-confidence, opportunism that I've been talking about, make a success of it, and have a wonderful career. Thank you very much.